And that's about how it is. And that's not what the intent was.
That's why I asked my question last week that I asked.
Yeah. It definitely wasn't, so, but it's in there. Dot. Okay. Nobody wants to evidently not.
Well, it rains, where's Scott? He's definitely.
Well, he talked like he's gonna be here. Cause he asked me at 7 o'clock. We have about a minute, I'm on the watch. I guess when they be here. You do openings and stuff.
Not for me,
Can we listen to it?
Yeah, you can listen.
That's information.
Yeah, that's information. You can, yeah, you can listen to the information and stuff. Yeah,
right?
but you don't have quorum and you can't
I
correct
got
it.
nothing on my back. It is.
I guess
We gotta have a
wait, we have 7:15 or 7:20 to see if the president will come. But I would, put some time to see people, when they do their stuff.
Joe, would you do prayer? Let's wait a little bit. Heard when David did it last time.
Only hit my truck. Was in his-
We're gonna go ahead and start the meeting, in there. We're kind of short on our group in here. We're not quite up to quorum here. So we're gonna go ahead and do the opening and have pledge and the prayer. We'll have roll call, and hopefully here in a little bit we'll have quorum. We only need one more person for a quorum. So we can go ahead and conduct business. Otherwise, we can receive information, but we're gonna be kind of limited what kind of decision we make unless there's one more person show up for the plan commission. So if you would please rise, and have Daniel Walker lead us in the pledge, and Jeremy McClellan will follow the prayer.
Allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Father, as we come together today, O Lord, as this group of men, and we ask Thee, O Lord, the guidance upon the decisions that we make for Washington County, and we just ask Thee, O Lord, that each and every one here be blessed. In the name of Jesus, amen.
Roll call as of right now, we are missing Philip Marshall, Evan Day, Adam DeFore, and Scott Martin.
That's correct.
Okay.
And then your board of zoning appeals,
We have quorum, well, we have a quorum, myself.
have Danielle, Max, and Daryl. And, yeah, so you have a quorum. If you want, somebody want to call that meeting to order, or do you? It's up to you.
We will call the meeting to order if we listen to, our,
Okay.
so if you wanna do that.
All right, let's go ahead for the business wise and stuff, and so we can defer. We'll hold off on the Plan Commission Director Report and the old business McFeeters until we see that we've got a quorum to handle that order of business. So at that, Danielle, I'll turn it over to the BZA to go ahead and conduct the meeting. If you want to thumb drive and go ahead and run this, if you want KK to be on.
We're in order, does that sound good to you guys?
So we want to do the rules first?
Yes.
Okay.
Do we have copies of that for?
I don't know if anyone
Okay.
caught that or not.
Do you guys have a copy of the rules and procedures that she's gonna talk about?
Is that the one she gave out last
From
time?
last time?
Yeah.
Okay.
I have, and then there's new stuff that
New
got
stuff that was
emailed, but I don't know if anyone made hard copies of
I
that.
can do that.
Okay.
If I've got.
Should you get that?
I didn't know.
Yeah, thank you. It's- Okay, little background on this. What we had were, for the Plan Commission and Board of Zoning Appeals, very, very different rules of procedure that they operated by. And so the idea was to make it easier on members, and some of them were on both groups, to make it easier on citizens, staff, the attorney, myself, the public, everyone. If their rules were similar, it would make a whole lot more sense. So this has been an attempt to kind of fill in the missing pieces that some of the rules that they had worked on in-house had, and to kind of make them more similar. So what we had in April was you got part one of the rules for both the Plan Commission and the BZA, and you are tonight getting part two. And as with the first part, what we saw is that some things in it applied to both groups, Plan Commission and Board of Zoning Appeals both, and that is noted with an all next to it. Some things are going to be different because of differences in duties and state law issues and so forth, and so those are marked. So if it says PC, that means Plan Commission. If it says BZA, that means Board of Zoning Appeals. And so there will be differences between them. So what we had last time, we were finishing up with what happens when you have a request to withdraw a hearing. And since we did that, I did a little bit more thinking on it and added a little bit more to it, which is basically saying, just kind of standardizing the language that we had before. So 5.05 was in what you got in April. We have changed that slightly to try to standardize it with the language about other things Basically, what we're saying is that you have to tell us in advance in writing if you want to withdraw a case. And in that point, the president or chairman's notified of it before the meeting, or you can come to the meeting and request at that hearing that the case be withdrawn. However, once the public hearing has been closed, or the chairman or president has ordered a vote, you cannot withdraw it. So that's the new information that's added, and that's fairly standard. So that once a vote is called for, you can't have somebody say, oh, wait, I'm changing my mind, I want to withdraw it. And you also cannot, once the public hearing has actually been held and closed, ask to withdraw it. So that is what's 5052 is kind of the new information that was not in there last time. Moving on to Article 6, the final disposition of cases. This is all new tonight. And we have separate sections for Plan Commission and Board of Zoning Appeals as far as the action that they can take, and that's because they hear very different cases. So 6.01, the first one up there, talks about decisions by the commission, and the Plan Commission does two different things. On some things, they make a recommendation to the Board of County Commissioners, and on some things, and that's what number 1 is, matters where they are simply recommendation makers, this group is, instead of final decision makers. And then number 2 lists items that the commission makes a final decision on. And so those items do not go to the Board of County Commissioners under Indiana law. So the items that the commission is empowered to act on under state law are listed under 1 and 2. One are the things that they make a recommendation to the commissioners on, and it's spelled out very specifically what the options are there. You can either recommend adoption, you can recommend that the proposal not be adopted, or you can make no recommendation. And sometimes that happens if there's a tie vote that you just can't break, for example, and you're just locked at, 3-3 vote over and over and over. You can forward that application without a recommendation. Number 2, when you make the final decision, and here we're talking about subdivisions and development plans, if that's something you do in the future, or any other action where the state law basically gives you the right of final decision, there you either have to approve it or deny it, because you're the ones making the final decision. So that just spells it out very clearly, so there's no doubt about that. And then we talk about adverse decisions. If, 2 different situations, if you make a recommendation to either deny or not adopt something, then it would not be able to be heard again by you for 1 year. If you send something to the Board of County Commissioners under B, and they make a denial of it, it could also not be heard again for 1 year, unless it is C, a substantially changed proposal. So this is to keep someone from coming in and just refiling the same application over and over and trying to wait for people on the board to change or wear you down or whatever it is. But if they do change it substantially, if they change the amount of property involved, the number of lots, those kind of things, then they can come in and file a new proposal. So that's what C is the exception to that.
Do you want to take comments as you are going? Do you want to take comments or questions as you're going?
I don't know, how do y'all want to do this? We can.
Well, my comment or question was, is there anything magical about 1 year?
No,
Is that what you
it is not.
normally find in your consulting?
It
or-
varies. There are some communities that are short as 6 months, and some are as long as 2 or 3 years. So that's kind of a happy in between. And one of my goals as I did this was that I wanted to make sure that anytime this situation came up, whether it was that a case was dismissed, whether a case was denied, whether a case was withdrawn, that it was the same standard amount of time, because it was all kinds of different things. So we've just kind of put a 1-year period in here because that's kind of the average. But that's certainly something that you all can tweak. There's nothing that in state law or anything that sets that time period. So that's totally your decision what that should be. Just the recommendation that we want to try to keep them uniform to avoid the confusion for everybody. Yeah, good question. Then we have a separate section that talks about actions by the Board of Zoning Appeals. And under the Board of Zoning Appeals, there are no things that the board is charged with that have to go to the county commissioners for approval. The board makes final decisions on everything that they hear. So it's slightly different than the Plan Commission. And so that means everything that comes before the board has to have either an approval or denial. There's not going to be a no decision in case you're tied. You're just going to have to keep at it till you come to some resolution of that. And as with the same thing we just talked about with the Plan Commission, the same kind of idea on the adverse decision. Just again, waiting a year or having a year from the time that the board denies it, or having a substantial change. And with that substantial change, some communities allow staff to make that decision. Since we're still kind of a new Plan Commission and Board of Zoning Appeals, I have put in here kind of another option that other communities do, where the applicant actually has to come before the board or the commission and say, here's what's different. And you guys can say, well, the fact that you're only moving that line 6 inches isn't enough substantial difference to refile that case. Or you can say, yes, the fact that you took 1 lot out is a substantial change and we will hear it again. But leaving it up to the board or the commission to make that decision there. You could delegate to staff if you wish to do so. My recommendation is that you just go ahead and do it as a board or commission. Then we get to findings of fact. And very simply, findings of fact are something that is different than a set of minutes for a meeting, and it sets forth the determinations that have been made by both the Board of Zoning Appeals and the Plan Commission. And it includes any conditions of approval that might be part of that, or it sets out the reasons for denial if it is so. And so this is just acknowledging that there should be findings that are put together, and that's something that typically either the attorney or the staff planner or the consultant will do. Sometimes communities adopt them at that same meeting, sometimes they adopt them at the next meeting, and that's something we can fill this area out a little bit more when we've discussed this and figure out how you all want to handle that. Another action that can be taken by both the Plan Commission and the Board of Zoning Appeals in 6.03 is to actually dismiss a case. And this may happen sometimes if you find that no one is coming to represent the application, which sounds funny. Why would you bother to apply for something and not show up? But it happens sometimes. Or when you find out that there's really not, there's lack of jurisdiction. If somebody files something and then you suddenly discover it's not in Washington County, it's in the adjacent county or something, the proper way to deal with that is also to dismiss it. And again, the standard time period, if someone doesn't show up and represent the case after 2 consecutive meetings, either the board or the commission could say, well, we're just going to dismiss it, and then that person would have to wait a year before they could refile that, unless there is something substantially changed, and again, they would have to come to the board or the commission for that. Then we get into some miscellaneous items in Article 7, and that is amending or suspending the rules. So again, the Plan Commission and the Board of Zoning Appeals would both have their own sets of rules, which would be similar but not exactly the same. And from time to time, there may be the need to amend those rules. And so this spells out that that can be done at either a regular or special meeting, and it has to have the affirmative vote of a majority of the members, not the majority present, but of the whole membership. And then as far as suspending the rules, under special circumstances, you may need to suspend a rule if you've got a huge hearing that is in, the high school auditorium, and your normal course of business isn't working, and you want to take things out of order or something. Reasons like that, you may have to suspend a rule, and this is something that's very common in all sets of rules, and it allows you to do it at any meeting by an affirmative vote of 3/4 of the members present. So more than a simple majority to overturn that. And then as far as remanding cases, the Plan Commission may remand or give authority to hear plats to a plat committee. And also, the plat committee is authorized then to review and hear things for the Plan Commission. And if you want to do that, we need to spell that out a little bit more in here. I don't know that we're ready to do that yet, so having this in here just keeps that option open, so 5 years down the road, if you want to have a plat committee and development is picked up and for some types of, minor subdivisions, maybe somebody platting 2 lots into 1 or something, it makes sense to do it. You've got this opening in here where you can go back and allow that. So 7.02 is almost more just kind of looking toward the future and a place safer for now. And then we get into Article 8, ethics, and this was touched on a little bit back in the section you got in April 3.05 about quorums and voting, which talked about if someone had a conflict that they had to get up and excuse themselves. If y'all remember our discussion about this. This goes ahead and talks about what the actual conflicts of interest are. And this is based on Indiana Code, which lists conflicts of interest for both the Plan Commission and the BZA as being the same things. Anytime there's a direct financial interest, anytime there's an indirect financial interest, or this is a new one that was added just recently, a few years ago, anytime there's bias or prejudice that makes you unable to be impartial about a case. So whether it's about an applicant, a representative, a property owner that's involved, whatever it is, if you can't be impartial, state law now says that constitutes a conflict of interest. And again, those are exactly the same things. They're different citations in the Indiana Code because the board's covered in one section and the Plan Commission's covered in another, but they're the same conflicts that are listed. Then, based on a court case, I've added another item, a 4th item, which says, additionally, a member may claim a conflict if the situation weakens public confidence and undermines the public sense of security. So in other words, if one of you, even though there's not an actual conflict, but you fear that the perception of a conflict is there, you may excuse yourself as having a conflict of interest based on that perception and your concern for how the community might see that. Now, for all members, both Plan Commission and Board of Zoning Appeals, the state law sees those conflicts of interest as being self-regulated. If there is confusion, the member may ask the attorney for some guidance prior to or during a meeting to kind of help them talk through if there is an actual threat or conflict of interest That particularly gets a little tricky sometimes with the indirect financial interest, how much financial indirect interest, if it's my 10th cousin, is that an indirect financial interest? Those kind of things. So that recommends the discussion with the attorney, and also allows that the member can raise it at the meeting, at the public meeting, but makes it clear that the final decision is up to the member themselves, not through any vote of the board or commission, or a determination by the attorney. If anyone else has a concern about possible conflict of interest, say a neighbor or another member on the plan commission or the BZA, then that person is directed to consult with the attorney, and the attorney will work with the planning director to make sure they have all the facts of the case involved, and then contact the member that may have the potential conflict to discuss it. And this should happen as soon as possible, before the public meeting and outside the public meeting if at all possible. And that discussion would only be made part of the public record if the member determines an actual conflict exists and goes on record at the meeting saying so. We've added some clarification on the next one, C, that direct or indirect financial interest would be interpreted broadly to include any member who receives legal notice of a pending case. So if one of you are a surrounding property owner, instead of trying to figure out whether that makes you have some kind of conflict of interest, we are just going to state for the record it does, just to make that a little clearer there. And then we're also clarifying that it's not necessary to first determine if your conflict of interest would actually affect your vote or not, to try to figure out if you've got a conflict. That's just to kind of help clarify things. E, if one of the members of the Plan Commission or Board of Zoning Appeals knows that they have a conflict, they're instructed to immediately disclose that to the planning director so that an alternate member may be appointed to participate in the case. And that will keep you from all showing up and finding out there's not a quorum. F, the member that has the conflict or the president or chair on behalf of that member should announce that there is a conflict at the public meeting so it does become part of the public record. G, and again that applies to both groups, the Plan Commission and the BZA. G says that a member may not represent either themselves or anyone else on a matter before the board or commission or the county commissioners, and that is whether that representation is paid or voluntary, so that you can't jump from one side of the table back and forth.
Does anyone else have any kind of time frame for that, even after you go?
That's a very good
I
question.
mean, I think the state ethics representatives and senators aren't supposed to become lobbyists,
Yeah.
the next January 2nd when they resign or lose re-election.
Yeah, I have not seen that in the rules before, but that's a good question. I know that like some cities and counties have in their employment books that you can't leave and take a job like with a consultant or something that serves for a period of 6 months or a year or whatever. I don't know, that's something we may want to talk about. Yeah, good point. And then H is that if you do have that conflict of interest, just spelling out that you're not entitled to receive mileage or compensation for attendance if that's available for a meeting where you're disqualified because of that conflict. So again, just trying to spell everything out there with the conflict of interest so that there's no confusion over what happens. The bottom line is that it is up to each individual member to determine if they have that conflict or not. part two is something called ex parte contact. And ex parte contact simply means contact outside of the public meeting. And under Indiana law, there are very, very specific prohibitions. In fact, it's illegal for anyone to approach a Board of Zoning Appeals member to talk about a case outside of the public hearing for. It's not the same for Plan Commission. Don't ask me why the state law set it up so it only applies to the Board of Zoning Appeals and not the Plan Commission. I do not know, but that's the way the state law is. And so 2 right now talks about that ex parte contact for the Board of Zoning Appeals. And as we go through this, even if you're not on the Board of Zoning Appeals, if you're on the Plan Commission, one of the things we need to address is to talk about whether you want to also follow those same rules. Many communities adopt the same rules for their Plan Commission that the Board of Zoning Appeals already has to follow. So that is up for the Plan Commission. That's one of the points that you really need to think about as a Plan Commission, is whether you want to follow those same rules, similar rules, how you want to handle ex parte contact.
I guess then, if they have questions of the application of that type, then that solely has to be directed to the plan director?
Right, that's a really good question, and that's part of what I've got in here, David, is that you basically are supposed to direct those people to the planning director if they have questions about the application, and then ask them to submit either written comments or attend the public meeting if they want to comment on that matter.
Okay.
And so that is what the BZA has to do, and it's an option, and the Plan Commission again could choose to do that. But yes, all requests in the same spirit, that means that BZA members shouldn't do the same thing and contact applicants asking for more information. If you as a BZA member want more information, then you should go through Travis and ask him to get a hold of that information for you, instead of contacting that member directly. Let me see if there's anything I missed there.
What about,
Oh.
what if you have a group, or you want to go out visually, look at the site?
Yes. That is a little dangerous to do, because that gets into the open door issues. That's not even necessarily this. If we get too many of you together, then that constitutes a meeting, so we have to be careful about that.
So that would, the numbers would be the issue.
The numbers are an issue.
So, but if you had a planning director
Yeah,
in
an
less than
individual could definitely do that, but, you know, again, what I encourage is what I call drive-by site reviews. You don't really have to go meet the property owner in most cases to get a good idea of what that site is like. So, you know, keep that in mind. And the other thing is, when you get if you get more than one member together, it's very tempting to talk about things, even accidentally sometimes. And so part of what happens is in here, we're saying that you're not supposed to talk to each other as BZA members either before you're in this public setting in the meeting. So even if Travis, for example, sends you all information by email, don't hit reply to all and start saying, oh, I'm not sure if this really meets our standard, and somebody says, yeah, I think they're missing this. That would be prohibiting that contact. So the electronic ages make things a little bit tricky for us that way too. So basically, don't talk to other elected officials if they want to sway your vote. Don't talk to the applicant, don't talk to neighbors. You can talk to staff. Staff is safe. The attorney, the staff, they can help you get more information, answer questions, but also don't contact any of the members of the public. The other thing is that because of the electronic age, one of the things that we want to do is also make sure that the public realizes that it's a state law that prohibits you from being able to do that. So my recommendation is that we put that on the county's website. Just a little note that Indiana state law, and we can cite the number, prohibits contact outside of the meeting with Board of Zoning Appeals members. Just to give people a heads up and then direct them to contact Travis if they need more information. And that would be something, again, if Travis is contacted and somebody says, we want a list of all the BZA members and their phone numbers, then he would say, under Indiana state law, you're not allowed to contact them outside a public meeting. So that's just not anything we can change, that's just the way it is on that. So then the big question is, that's what BZA basically has to do. And then the question would be whether Plan Commission wants to also do some version of that. And that's really all the new stuff we had for the rules tonight. We have pretty much covered everything else in our April session. And then these rules would become effective on the date of adoption. So what we would do is each group would have to adopt their own rules, and I would pull this apart and basically give one set of rules to the BZA for review, one set to the Plan Commission, and the things that as a Plan Commission, if you review something and say, gosh, we really don't like this year, we want it to be 2 years, or we want it to be 6 months, whatever, that's something you probably want the BZA to consider too, so everybody starts to stay somewhat common in these things. A lot that I've been throwing at you since April with all these rules, but it is really important to have these in place. And so this is kind of how we do our business, basically, the day-by-day kinds of stuff is what we find in the rules here. Any questions for you now? Kind of what I see happening is that next month, the Plan Commission gets a set of rules that they're looking at, the Board of Zoning Appeals gets a set of rules that they're looking at, knowing that they're similar and kind of starting from the same place, but may have some differences based on what you're enabled to do by state law.
Well, we got 2 Plan Commission on BZA, correct? I know, just talking out loud in there, a small community, and their Plan Commission with that many members, you've got a potential of 10 or 11 people in there, meeting somebody in the grocery store, being application, or somebody make a comment. I mean, other than being just plumb rude, to say, I just can't talk, about it, period.
Well, and I know you small-town people have good manners, so I'm not expecting you to be rude about it, but I think that when you explain to people, at least for the board members, I don't have a choice. I'd be breaking the state law, and so would you if we did this. So we don't want to get in trouble for doing that, and we're gonna direct you to Travis. And then depending on what the Plan Commission does, you can still be very nice and polite about it, as long as people understand that it's something that, is either governed by law or by rules, depending on what the Plan Commission adopts.
Okay.
So, and the reason we do this, we get back to it, why do we want to keep people from contacting you outside the meeting? The idea is so that everyone sitting here hears the same thing.
Right.
That's the bottom line, is David wants to hear what, everybody else has heard, and vice versa, and not some of you making decisions on less or more information. So I think that's the intent of that state law, is to make sure that happens in a public meeting kind of format.
Okay.
So are you able to have a conversation, just a conversation about something else with
Yeah.
someone, that's okay?
Right,
But
it's
not
just if
not
it's
their
about
application.
the case.
Okay.
So if you guys are talking about general amendments to the zoning ordinance and somebody wants to talk about that, that's fine. It's only if there's a particular case that they want to either try to talk to you about, that's when the red flag comes brings up. But if it's just general county business, general, ordinance questions, those kind of things are fine.
Okay.
With your, with one of your basis being for a conflict of interest being the perception of the public,
Right.
I would suggest that the planning commission adopt or include the ex parte communication rules. If you're concerned from, what your perception from the public is, if the public knows that you're having ex parte communication with an applicant, I'm talking about the planning commission, you're gonna shoot that perception pretty quick, quite frankly.
Yeah, I think
Because
that'd
the
be
perception
appropriate.
is the reality.
You know, the thing about it is, we go through, and I'll just, for instance, in there, you know, this ordinance has been all new to us all as far as implement. And Travis corresponds back with me quite a bit, because I've been part of the actual implementation of the rule and stuff in there. We're trying to figure out where we're at so he can make remarks back to the people, you know, correctly
Right,
about, you know, where things stand at.
right. And that's
So-
perfectly fine.
Right,
You can correspond with staff, any of you can correspond with
so we're still
Travis.
gonna have to third party that
Yes,
mechanism, even though we may think, well, it's more efficient if I were just to speak.
that's true.
And that, but we need to go through that conduit to give a separation.
Yeah,
Okay. Well, in my instance in there, and I'm with Mark, in that, for perception wise in there, it's probably best that we adopt almost the same type of rules as what the BZA does. And that way, we can't say, well, you got two members here that are on the planning commission in there, that, you know, and so everybody's on an even point.
right. And that is typically my recommendation to communities, just to make.
I'm
things
surprised you even
easier.
put it as a suggestion.
Well,
I was waiting for stronger language than that.
you know me, yeah.
Yeah. Okay.
Any other questions? Okay, so what I'll do then is go ahead and pull it apart and try to get to you in plenty of time before the next meeting, so you all can have a chance to look through it, whether, the board wants to meet at the same time next month, or if they wanna have a separate meeting. I'm gonna leave that up to you all to
Okay.
figure that out.
All right.
Okay. What's your
Well,
program, Mr.
I would like
President?
to go back to our original old business planning commission director. You don't have basically a report, do you, in that? So I'd like to go to the old business that's on the table. I want to acknowledge, as far as with the planning commission, that Scott Modlin is here now in attendance in that, so that allows quorum in that, so we can go to part of our own business. What I'd like to do, KK, is go back to that and then come back with the overview of ordinance, which is planning commission.
All right.
All right, now planning director is showing that he has nothing to report on it. We'll go old business. We're gonna open back up for the feeders application. We had some information we needed to receive back from the state, and our legal counsel has done that. So at this time, I'd like to defer to Mark Clark as our legal counsel.
You want to make have somebody call it from the table?
All right,
You do, it's,
all right, it's been tabled, so I'm calling for it to come back up for
Somebody
business.
should bring it off the table.
Yeah.
Daniel.
Daniel Walker, to a second. Scott Modlin, second. Open for discussion. Seeing none, we'll take the vote. All in favor of bringing it off the table, signify by saying aye. Aye. All opposed, same. Motion carried. Okay, it's up for order of business. I'm gonna turn it over to Mark Clark for his findings.
Well, basically, there were two issues from the minutes that you asked me to look for you or to research for you. And one was kind of a definite, or not kind of, what a definition of contiguous was. We got off onto the issue of that the parcel from which the new two animal operations or two animal barns, that parcel, was it contiguous to the other parcel, the roadway, form a boundary, what did that do? After looking at it, after considering a couple of court decisions, after looking at a couple of definitions under the annexation statute, after talking to some individuals from Mr. Joe Williams from the permit section of IDEM, let me say it this way as well. You've hired John and I both to be your counsel. So John and I talked about it too. And basically we find that we find these two parcels property to be contiguous. The reason is, if you can remember kind of the layout of them, there's one, the parcel where the two tracks are going to be on here, since David's still playing, this is the parcel.
I'm trying to pull it up.
Right, so this is the parcel where the two tracks, where the two barns proposed are to be on. This is the track, then it goes way up in here where his current CFO operation is. That makes these contiguous. I mean, Oregon Springs Road does not create a boundary. The assumption is he owns to the middle of the road. That means this tract owns to the middle of this tract of the road. This piece of property comes to the middle of this tract of property. I don't know what that distance is there, but that makes them contiguous. They actually physically touch. So we don't have a definition of contiguous. The statute in Indiana dealing with plan use does not have a definition of contiguous. IDEM does not have a definition of contiguous in the Indiana Administrative Code. But based upon what John and I have looked at, we believe it is our opinion, as I've written to you in the memorandum I sent to you, that these two pieces of property are contiguous. What that does for you, I don't know, okay? Because you don't have anything under your ordinance about whether what the effect of that contiguous position is. The second thing, which was really the first one that was talked about, the issue was what does IDEM look at? Upon having discussed this matter with Joe Williams and with Molly Bogan, Boegin, one from the permit section and one from the enforcement section, IDEM has told us, and Mr. Williams stated that he would try to get this in writing to me, but he has not. Mr. Williams stated to me that it is the position of IDEM that if it is under common ownership, then IDEM considers that an expansion of their operation, of a CFO operation. And in looking at that, when he told me that, and this is all from me now, and Mr. B, our discussions, it's all from me and Clark. We believe IDEM takes that position because when you look at the statute requiring a CFO operation permit, it talks about a CFO operation, and IDEM regulates an operation. So it doesn't matter where that operation exists. All right, if you're following me. Mr. McFeeters has a current operation. He could put two more barns on the other side of the county from himself. And that would still be the expansion of his operation. All right, of what he is doing in that business. And if you think of it in those terms, that an operation is the totality of the business, if you will, then you can see where it comes from that Mr. Williams would tell me, well, we don't care if it's under common ownership. We don't care whether it touches, doesn't touch, where it's located. That's an expansion of CFO, and he'd have to get a permit from us under Section 1 of the permit regulations under 13 whatever, where it says you gotta get a permit for a CFO or an expansion of a CFO. So it's our opinion, as your council, that this is an expansion of an existing CFO. If it's an expansion of an existing CFO, then no, you really don't have jurisdiction over it, because it's under the Indiana Department of Environmental Management as an existing CFO. And therefore you go there. Now, what happens if he goes there and somebody at IDM says, well, yeah, that's what Williams may say, but that's not what we're changing our mind, we're not gonna enforce that now. I think at that point you ask your applicant to get that at least in an email from someone at IDM. IDM's not gonna give that to you in writing because it'd have to go through the Attorney General's office, blah, blah, blah. It'll take 6 months to get that, maybe a year and a half, okay? But at least at this point, it's our opinion that that you do not really have jurisdiction over it because he's in excess of the number of fowl in his operation, and this is simply adding to that. And because he's adding to that, this is an IDM permit obligation. There was also kind of a question, the third issue about the owner-operator residence, whether this parcel, because I think it is here, yes, it's right here where his residence is, whether that would qualify in the way you have written owner-operator residence in your ordinance. That would not qualify. That residence has to be on the parcel. And this is the parcel. Hang on just a minute. Let's find that.
You want to find that?
Nope, I got it right here.
Okay.
Too many folders, too many pieces of paper. But as you've written on the scoring sheet, owner-operator, on-site residence award, the residence must be located on the parcel of land used as the subject operation. It's more there than saying parcel. Used as the subject operation. The residence is not where the subject operation is proposed to be. Again, it's not got anything to do with about it being contiguous. It's simply not where it's going to be. Now, again, I said in my memorandum to you, this was under a Carmen deed, has 2 separate tracts, and it has 2 separate parcel numbers awarded by the county. I think this is a good kind of first test case for you. You may want to go back and look at that definition. Now, was that really your intent, that this house, that the resident has to be here as opposed to across the land? I don't know, I wasn't here when you wrote it, okay? But I think that's something you may want to go back to and look again. What effect does it have that the county gives them 2 different parcel numbers? What effect does the continuous have on you? We got wrapped up in that at the last meeting. IDM says it really doesn't matter to us. Does it matter to you? Do you want to say in your ordinance, we're not going to regulate anything that is continuous to an existing CFO issued by IDM? And if it physically touches that piece of property and you're wanting to build more barns on it, we're sitting with IDM. That'd be up to you. But those are our legal opinions based upon the 3. And I know Travis asked at the end some on public use, and we didn't get there. So really, I don't know in this case matters that much. But the 3 issues that were raised, those are our legal opinions on it. It is contiguous. It is an expansion of an existing operation. It's not qualified for the on-site operator points.
Danielle?
Yeah. I guess then that opens up some questions that I have about, then if this is just an extension, then.
Expansion.
Okay, okay.
I used the term extension, that's wrong.
Okay,
We should refer to it as an expansion.
okay. So in our ordinances, in section 402, we talk about substitutions and extensions of non-conforming uses. I'm assuming that he would be considered, that the McFeeder operation that's there would be a non-conforming use. I don't know, we haven't looked at that, but it says that, in all cases involving a substitution or extension of a non-conforming use, they would need to file a petition with the BZA.
No,
This
you
isn't
don't, that's
following
not what
that.
this is.
Okay, so I guess
If
I'll.
you had, and you have not done this,
Okay,
I don't think. But
okay,
if you had classified this whole area as residential, and there were already existing 2 barns in here,
okay,
that would be a non-conforming use. And if Mr. McFeeters then wanted to sell this, if you wanted to, let's change it from fowl to hogs, he could come in and do that, because then it's a non-conforming use, but he's substituting what type of non-conforming use.
so what would be
Then-
an extension?
I don't know, because I don't know
Okay.
what you mean by an extension.
Okay,
Maybe if he took it this way, if he owned this lot up in here, and he said, I now want to extend this non-conforming use up in here, and build another barn here, but I'm still under, don't get confused with I'm trying to answer your question, okay? So now he wants to extend this non-conforming use to the lot up here, because he owns both lots, and they're contiguous, and that's just a property line between tract 1 and tract 2. That's what that's talking about.
Yes, Scott?
I got a question, as far as, make sure I'm on the right page. Am I understanding then that the decision for this is gonna go to IDM? Because it's gonna be an expansion of his current CFO. So basically, we don't have a decision or a reason to make a decision. His application is null and void, or is there, is there still that issue of that score sheet and,
I don't think there's an issue. I think the decision you need to make, you have to recognize is, yes, you don't, I think you need to say in your minutes that you recognize that this is an expansion. You've been informed that this is an expansion of the IDEL CFO permit, and that he will have to go get a permit from the Indiana Department of Environmental Management. Travis is therefore not authorized to issue the permit to him, because we're not the proper authorizing agency. Period. Now, question about the score sheet, I think is for another day, because that's going to take some discussion and some amendment to your current ordinance, and that's going to have to go back in front of the commissioners. Okay, I mean, I'm not trying to postpone, but really the issue, right, what you got to do right now. Yeah, and I think right now that's is what you say, is that we're not a proper. This is an expansion of his existing CFO operation, and he has to go deal with that with the Indiana Department of Environmental Management.
I don't know, as we asked him the question last week, and I figured he would have been here today, is if he's under the state permit now, why would he change from CFO to an AFO? Why would he want to change from one permit to another? I didn't understand that last time when he presented that. I don't know.
David asked him the question of why he wanted to build on this particular parcel as opposed to where he already had his existing buildings. As I recall, his basic answer was convenience.
Oh, I understand that.
Okay.
I understand why he might want
Well,
to.
he may not, I mean, the point is, in researching this for you, I went to the Indiana Department of Environmental Management site. That site had some related links, as a lot of sites do. One side of that was to the Indiana Poultry. commission or agency or whatever it is, okay? The Producers Association, if you will, okay? Nothing about what an expansion of your current CFO is under that. And they had a section about needing to go get a confined feeding operation, and what's the other state permit you guys did this morning? And CAFO. They had a discussion about CFO and CAFO, okay? But nothing about what's an expansion. One of the related sites was Purdue. And Purdue had a nice little 16-page brochure. Talked about CFO, talked about CAFO, didn't talk about what's an expansion. Okay. I mean, you don't see a lot of information about the difference between if I go to a completely separate lot, so to speak, is that an expansion? Or if I keep it under the numbers, is that an AFO? And I'll say this, and somebody out in the audience may do it. I mean, how does IDIM find out? How does IDIM, if he were to simply go and start building on these lots, on this lot, how's that, and doesn't call up IDIM, and he doesn't come to the county, how does IDIM even know? Well, unless a property owner calls and says, hey, calls IDIM and says, hey, I just got a question for you. I don't know how they find out, other than permit section doing, normal, however often inspections they do of their CFO operations. And driving out there and saying, kind of like what Travis does on our county. Driving around and all of a sudden saying, hey, why are you building that barn out there? You didn't get a building permit. I don't know. I don't know how I even supposed to find out. But that's the best answer I've got for you, Jerry.
I don't want to put this as a public format, but we have a member from BZA that would like to talk toward the planning commission.
I'd just like to say, I thought, what the ordinance was for site placement, and in your section 70121, you have, distance for both AFO and CFO, as well as the animal feeding operations that, fall below those numbers. So I was assuming that the requirement to come with the point system would fall under that too for the animal feeding operation expansion, because the county's trying to claim the right to take away from IDM the ability to say this is where we feel the site placement should be.
I think that was kind of addressed in the discussion, and I'm going to go at liberty to how this ordinance come about. We didn't want to limit a existing operation from going ahead and expanding in their operation in there, and they could do that as long as they stayed within the parameters of what the new ordinance as far as the distances and stuff. Like they wanted to put an additional building in that, but the thing about it is the AFO, CFO information, for instance, if you got a CFO operation, and you all of a sudden you say you want to put in an operation of an AFO on that same piece of property, you're not going to be able to do that, because by state law in there, you've already got a CFO, so it's just an expansion of that, so you're going to have to go CFO. Now, if you got an existing AFO operation in there, I don't think that you can say that you've got another AFO operation beside it. KK, help me out.
I would agree. Yeah.
So ultimately, your numbers would get you up to what they would classify as a CFO. So then you'd have to be permitted as a CFO. Right now, we've got a CFO operation that's continuous property because it's on the same property. Ultimately, it's verified he needs a confined feeding permit to expand. But the terminology you got in 402 is to kind of take the grandfathered operations and allow them to go ahead and operate and expand in that grandfathered type of position.
That's how I found it.
That's why, now, so I think where we're at in right now, this building, these buildings can be done, but the proper process is that it needs to go through a CFO permit process. That's the first thing that they can do, you know, now, so
But they still have to meet our setbacks.
they have to meet the setbacks.
Even though they have a smaller number of birds than what, in that specific parcel, even though they have a smaller number of birds, they now have to follow the setbacks of a CFO.
Correct,
So instead of 400 feet from nearest residence, now the operation, those buildings have to be 600 feet. Is
yes,
that correct?
yes. That's the way I interpret it. Now, the one thing that come up, and I don't want to deliberate on the document, you know, so much, but I wanted to go back to the findings, because in the public hearing, we tried to specify to keep it toward the application as the ordinance is written. So I would rather defer some of the other comments that I've got in some of our findings to talk about the ordinance at a different section of this meeting than I would now. So right now, the way I see it, and this is all our discussion of our plan commission to give Travis direction on it, is with IDM's findings on there, I see that this operation needs to get a confined feeding operation permit.
He needs to get whatever he has to get from the idea about an expansion.
Right.
And I don't know what that is. I mean, I don't know if they'll make him go through a whole new permit process. I don't know if there's a, shortened permit process. I don't know what they'll do, but to establish one or to expand one, you have to get a permit from the ID. And that's where he needs to go, in my opinion. We're talking about it.
Okay. Plan commission, we're going to make a motion to give direction to deny application until it comes back with a confined feeding operation permit.
I'll make a motion that we deny until we get permit results back from Indiana Department of Environmental Management.
Okay, Scott Bosman's made motion, do we have a second?
Second.
Jerry McClellan made second. It's open for discussion. I mean, this is really our first real test with the public hearing, and I appreciate the public as far as participating in it. It did show with Drew Wright, brought several issues up to our front in there as far as a new document, some things that we probably need to address with that, and with our determination from IDM, we have found out that it is an expansion of a confined feeding operation. So due process, it needs to go through a confined feeding permit process first before here. With that, we'll take it to a vote. All in favor of denying the application, signify by raising your right hand. Have it stand that there's 5, all opposed, same. Motion carried.
This is not Lake County.
Not Lake County.
Can't go across.
For Kentucky to do that. All right. So with that, there's a denial of the application as it stands. So Travis, can you be in correspondence with the McFeeters and tell them of our findings? In fact, we probably need to do this in a written order.
Certainly, yeah.
Okay, we need to do that in a written order. All right, that fulfills that. Before I go in there, I want to hit one more stuff while it's in there. We found out in this application in there that, some of us have been involved as far as help writing it. And in the owner operation on the score sheet, residents must be located on the parcel of land used as subject of the operation. I want the audience to know, as we are in discussion, the intent of writing this language of having residences there is that we didn't want any absentee ownership of operations. We didn't want an operation that went in there and put 2 or 3 or 4 buildings, 5, and we thought that we would get better husbandry and better maintenance of operation if the owner-operator was in a tangible aspects or distance to that operation. And that's what our intent was. Parcel is a bad word
Right.
to use. Parcel is a assessor and a taxation type of terminology, and it's used for that basis. The continuous land ownership is more of a direction of what we wanted in the interpretation. I know in my fact where I live at, I've got 150 acres, and I have 3 parcels by my tax in it. That doesn't make that it's 3 different separate operations or 3 different land masses. They are continuous land mass. And the parcel is, I had to read this document 3 times as I went through there to pick up this one piece of language in there where parcel. And that's a misrepresentation of what the intent of the document. The intent of the document is to have that person be tangible in land of being close to that operation instead of away from it, so.
And I think that's why I asked the question last week that caused some stir about, was that owner's residence the closest residence? Because that was at one time how we had thought about
Yes, it
defining
was.
that. And so when the parcel thing became apparent, it was a shock to me that that was not how we intended that to be, or in my opinion, how we intended that to be.
So to correct that, we have to go back through and make an amendment, correct? And it has to go back for approval for the commissioners. We'll have to go through public hearing in that process with that testimony for that particular document. All right, with that, anything else that you would like to bring up with this? Okay. All right, let's go back to the minutes. I know if you're here for anything else, you're more than welcome to stay in here to go through our ordinance and what we're doing in that. But if you're here for that decision, you're welcome. Believe we will not take any offense. Minutes that were sent out, are there any additions or corrections to those minutes at this time? If none, I'll entertain a motion to. Jerry made the motion to accept. Scott Marvin seconds, open for discussion. Seeing none, we'll take it to a vote. All in favor signify by saying aye.
Aye.
All opposed, same. Motion carried. All right, back to you, KK.
Okay. Okay, Danielle, you kind of got us transitioning to tonight's topic, because the ordinance amendment we're talking about is the non-conforming use section.
Good.
So you're right on task with where you wanted to go, or need to talk about that a bit.
Now you'll have to hunt and find where you're at.
Okay. Basically, a little background, we had gone through the ordinance when I first came on board and kind of said there are several sections we need to fill out. And we looked in April at kind of the first group of amendments, which were kind of administrative quick fixes, if you will. So we kind of went through that. And the next group that we needed to tackle is non-conforming uses and other non-conforming amendments, and we'll talk about that tonight. And then the next group of amendments, just to preview coming attractions, is to actually go into the residential district, which doesn't have standards. And so that's what I'm gonna start working on. So we're kind of methodically taking this step by step to try to fill out what's missing in the ordinance. And Board of Zoning Appeals members, I'm glad that a lot of you are still around, because what happens in the non-conforming use section often includes trips to the Board of Zoning Appeals. So this section of the ordinance is something that in the future may give the board a workout. So when you adopt a new ordinance, or anytime you change a zoning ordinance, whatever was already legally in place is considered legally non-conforming. If it was illegal to start with, it's still gonna be illegal. But if it was legally established, it becomes legally non-conforming. Some of us call that grandfather. So we're gonna talk tonight about that, and there was a lot that was kind of, a lot of holes that were missing. And your ordinance is new enough that you really haven't had a lot of issues yet. This kind of thing comes into play 5, 10, 20 years down the line, after things have been here for a while, and then you make some changes to the ordinance or whatever. So changes to this is to add, first of all, a whole new general non-conforming section that explains what the intent of it is. And what we were talking about before, this section was called basically non-conforming uses. There are a lot of other things that can be non-conforming besides the land use, including lots, sites, structures, signs. So we're going to try to address all those things that may not be in conformance in this section. And this confirms in section 400.2 that if it is something that is not changed, but again, due to the zoning ordinance being enacted or changed, it doesn't conform to the standards, that's okay. It's a legal, non-conforming situation, and may continue in that manner. So that's confirmed in 400.2. And then it also includes that sentence, a change in ownership shall not affect the legal non-conforming status. So the non-conformity runs with the property, not the ownership, and we're making that clear in the ordinance that you can sell it as long as the new owner does exactly the same thing. That's good. 400.3 talks about illegal status, again saying that if something is illegal, it's still illegal. So just kind of spelling that out. 400.4 is important. This is saying if you have already got a permit, or even if you've already submitted your paperwork, you're basically under those old regulations. So just because if Travis issues a building permit and then we change the ordinance this next month, that person's permit is still valid. They don't have to suddenly tear it up and do whatever the new ordinance says. So it was issued under that old ordinance and remains valid. There's an interesting section in here, 400.5, that sometimes isn't spelled out, but I think it's really important. And one of the ways that property often becomes non-conforming is when we expand roads. So if you look at 400.5, if we're widening a road and acquiring right-of-way, suddenly somebody may not meet the setbacks or the lot width or lot size that's required. And this section 400.5 says that if it becomes non-conforming because of the action of Washington County or NDOT with road work, that basically they're exempt from the non-conforming provisions. It wasn't something that they've caused themselves. It was an issue that was caused by the street widening by the county or by NDOT. So that is what 400.5 is talking about. Then we've got now a separate section for non-conforming uses. That's what 401 becomes, is all about non-conforming uses or land uses that are no longer allowed by whatever the ordinance is that's in place. And there's a provision that allows someone to come in and request a letter of non-conforming use from the Plan Commission. And that's something that's sometimes necessary if somebody's trying to get financing to do an expansion or a remodel, and the bank finds out that they don't have the right zoning. That can cause problems. So this is something that allows an official document from the government agency saying, as of this date, they're non-conforming, but they're lawful and they're legal. And so that is what 401.1 is, and we can work up even just a little form or something or a form letter that can be used for that. And a lot of communities do that again because it comes up with particularly financing if there's something new.
With this particular situation, we had been that for financing, you know?
Honestly, that kind of thing changes all the time. It has been in the past.
Yeah.
Yeah, whether we have some institutions that are maybe a little tighter than others, or some may change their regulations in the future, I don't know. At this point in time, it should work. It's been working, I'll
Okay.
say that.
All
So
right.
this is our best attempt at this point in time.
All right.
401.2 talks about changes to non-conforming uses in floodplains. And basically, it's pointing out that, yes, you're going to be governed by these non-conforming provisions, but you're not going to be able to override the floodplain regulations. Those are federally and state mandated things that we have adopted, so that's just acknowledging that. 401.3 gets into what happens. David used the example of changing out one kind of animal for the other or something. What happens if somebody wants to change the use that is non-conforming? And so this gets into that, this section, and says that you can substitute one legally established non-conforming use with another similar non-conforming use as long as it's not more intensive. So, as long as, in this case it would be Travis as the planning director, who's going to have that weight on his shoulders, can say, okay, having this number of chickens is not more intensive than having this number of hogs, and I'm basing that decision on kind of what the state sees as equal, that kind of thing, then that's something that could be changed out as a substitution.
What does intense mean?
That is something that's a very good question, and that's,
Because I
yeah.
see just the same thing. I mean,
Yeah, and that's something that we would want to probably define in the ordinance, but intense basically means anything from louder, longer hours, more of anything, that kind of thing. Greater, yeah.
More traffic.
More traffic is a very good example, yeah. So we could go ahead and in the definition section say, here are some examples of what is more intense.
Okay.
Then there is, here we go, Board of Zoning Appeals. If you look at 401.3.1.3, if there is a substitution or an expansion, the person who wants to do that files a petition with the Board of Zoning Appeals, and they hold a hearing. So you cannot intensify or expand or extend or move that use without the Board of Zoning Appeals looking at it and granting permission. So you guys become, as the BZA, not the Plan Commission, but the BZA, the way things are kind of set up in state law, becomes the ultimate judge of whether that is within the intent of the ordinance or not, for that change to happen. So that is something that, again, as we've got kind of a new ordinance, you may not have a lot happen, but your next generation of BZA members may. And that becomes one of the areas that gets a lot of work out sometimes in communities. Then we talk about what happens if a use is changed to a non-conforming use. If you have one of these grandfathered or non-conforming uses, and then somebody changes it to a use that's allowed by your zoning ordinance, what happens then? And what the ordinance, or what this is proposed to say, is that basically then you can't decide that you want to go back next year and change it back to your non-conforming use again. So once you leave that non-conforming use and become conforming, you can't change your mind and go back and become something non-conforming again. So it's, as long as you keep doing it, you're grandfathered. But if you come into conformance and you decide that you're going to not do whatever it is anymore, and you're gonna meet the ordinance, then you can't change your mind down the line and say, oh, never mind, I wanna be non-conforming and do what I used to do again. Yeah,
Is that not, that 3 out of 5 years that's in the blue book come
Yeah.
into play though, so that you have to let
yeah,
it be 2 years before you can tell them no?
that's a very good point, yeah. That there are some standards in there for certain land uses. Ag is one of them, where there is some timing that is, how long that cannot be operating before it's considered going. Yeah. We should probably clarify that. We should probably put a link in there to that, yeah, to that section of the ordinance. That's a good idea. Okay, then, still under the idea of having a use that's not conforming, there's a section on new buildings or structures. So if you have a use that is grandfathered, you can't build a new building or structure for that use without the Board of Zoning Appeals giving you permission to do that. So, again, back to the Board of Zoning Appeals for their blessing on that.
So are you saying no new building or structure?
Yes.
Okay, so that
But
Or
that's
do-
non-conforming.
Yeah.
should be inserted in.
But in an ag district, you wanna do expansion on the, existing farm. But it has to meet the criteria of the setbacks of the new ordinance, correct? I think that's correct. Cause it refers back to, you got to meet the standards. Yes, please.
All right, I'll go back and add some more language in there, make that a little bit more clear. All right. And again, that's an exception for that use. And then this next section talks about abandonment. Again, this would be not for those ag uses that are accepted, but for other non-conforming uses. That when that non-conforming use has ceased and has not been resumed for a period of 1 year, or it's been, the furnishings have been removed and not replaced for 1 year, then that is considered abandoned and it loses that grandfathered status. And so, I know you all are used to thinking about ag, but times that we see this is sometimes when there's a commercial use that's within a residential area, and it's been there a long time, and then it, the operator that had the restaurant or the store or whatever that was there, closes it down. And so then after a year, it would become no longer grandfathered, that commercial use in that residential area. But as long as that continued to be that commercial use, it would be allowed, even if it was sold from David to Danielle, and it still remained the same use, it would be allowed. So again, it's a little different for other land uses than it is for ag, just because of the differences in state law.
What,
But I'll try to clarify that.
What does most communities do, just with what you said, if Jerry owns the restaurant and he shuts it down, but he lists it for sale, and it's longer than a year, and then in 18 months, Danielle comes and wants to buy it as a restaurant, has he abandoned it, or has he not abandoned it?
Usually the case law would say he's abandoned it because it hasn't been in operation. Yeah.
Okay.
And what happens,
If it was listed for sale, would it be abandoned?
See, that's kind
yeah,
of
usually
question.
the court cases look at whether it's been in operation or in use. So,
And what about property taxes though?
yeah,
They're still taxing it as a viable business.
yeah, that's not usually what's looked at. What happens in that kind of situation typically is that the new operator, the person who wants to buy it, would either come in and ask for a change in zoning to make it conforming, so it's not zoned wrong anymore, or come in and ask for the board for a variance to allow that use. And because that is an unusual situation, you probably have a good chance justifying variance. So then that would be a permanent solution to what had been kind of a up in the air land use that had been grandfathered. So that's how most communities handle it, is to try to find a more permanent solution to that.
It's gonna have a dramatic impact on the saleability for the
Right.
opportunity.
Because that would typically be a term and condition of the sale.
Right,
Yes.
you would want, and if you were a smart seller, you'd be proactive and go in and try to get that addressed before we put it up for sale. But that's something, you know, there's a learning curve with our real estate community and stuff for some of these things. So it'll kind of be an educational process as things goes on.
Maybe a hard lesson.
Yeah. Hope not.
Not a very fun lesson here either.
But that's typically how it works. So that's the section on uses that don't conform to the ordinance. Then we have a section on structures that don't conform to the ordinance. So this might be a structure that's now too tall or exceeds the maximum height that's in your current zoning ordinance would be a good example of that. So that's the kind of thing we're talking about here when we talk about non-conforming structures. And so this says, again, this first part of it, 402.1 talks about that no permits can be issued for expanding that non-conforming use or to add residential units to it or something. So we're saying you're not supposed to expand that structure that's already non-conforming. 402.2 talks about what happens if that structure is damaged or destroyed. So if you've got a tornado that comes through, or it burns down, or something like that, and it is completely destroyed, it is not going to be reconstructed the way it was. If that happens and only, that should be 50% right here. That's what happens when I cut and paste sometimes.
But like in the airport, they're gonna oversee this. FAA. Well, because we've got an overlay right now of an airport that deals with heights and distances as this bowl goes
Right.
out from the airport. So really, they gave us the ordinance to implement in there.
Right, and this would apply to that ordinance.
That one right there,
Yeah.
okay.
Yeah. So this applies for all sections of the zoning ordinance, and that's part of your zoning ordinance, right?
Yes.
That overlay district, so anyway, so if it's less than 50% of its replacement value that's damaged, then you could go ahead and rebuild it as it was, that same height that it was before or whatever. So it depends on how much of it is destroyed. Now, these percentages are somewhat arbitrary. You can adjust those. You can say, it doesn't matter how much is destroyed, you still can't rebuild it. Or you can be very lenient and say, even if 100% of it's destroyed, you can still rebuild it as it is. That's really up to you locally to decide what you want those percentages to be. This is kind of a standard number kind of an average that I plugged in there for you. Now, there's also a provision in here that says you have to get a permit within 12 months. You can't wait 5 years and then come back and say, now I want to rebuild my too tall church spire again, or whatever it was. 402.3 talks about what happens if you want to add on to this non-conforming structure. And again, very clearly saying you can't enlarge, increase, or extend this structure to make it, to expand it in any way. So the idea, why do we do that? The idea is that you, over time, want everything that's non-conforming to gradually end up conforming to your current community standards. So you want it to be able to live its natural life, if you will, as long as it normally would, but then if it's torn down and rebuilt, you want it rebuilt to your current standards. So that's kind of where all this comes from. Some states, Indiana's not one of them, have something called amortization, where they say a non-conforming structure, sign, or something like that has a certain number of years, and then it has to conform. Indiana doesn't do that, but most states do. So we're a little different that way. We don't have, it could be non-conforming for 100 years if they want it to be. We don't have a timetable on that in this state. Okay, repairs and maintenance is a really tricky one sometimes with non-conforming things. Ordinary repairs and maintenance, we just said that they can't expand it, but they can do ordinary repairs. We don't want the building to fall down or the roof to cave in or that kind of thing, up to 50% of the current replacement cost. But we're saying that basically that it's going to be determined by an appraisal. So if Travis starts to think, you know, they're really replacing this whole building, basically. They put new walls in, new roof on, there's not much of anything left that was really there in this non-conforming building before. You can have them submit an appraisal that shows how much of that has been replaced or is planned to be replaced and whether it triggers that or not. So this is to keep somebody from basically replacing the whole non-conforming building piece by piece by piece and giving that longer life that way. So they're allowed to make the repairs they need to do to keep it safe, but not to basically totally replace the building.
There are certain certifications for appraisers and different types of appraisals. Actually, for instance, a business appraiser is taught and tested different than a farm appraiser.
Good point.
So where it says by a real estate professional, we need to put something in there. We need to put certified appraiser by certain types of appraisers. I don't know what we want to put in there, but I don't think we want to leave real estate professional,
Okay.
frankly, because they could just go get a salesperson and do that.
Good point.
Sales associate.
Okay, so again, we're saying in 402.4.2 that we're not trying to prevent anybody from keeping their buildings safe. We don't want it to be unsafe, but just trying to make it clear that you're not able to just go in and replace the old one with something totally new and perpetuate what you're doing. Compliance, a non-conforming structure, again, we're saying can continue to exist unless or until it has has to comply with these other standards. There are some special standards in here for non-single family uses. So when we are talking about a non-single family use, we mean anything except single family residences. And saying that those would have to be brought into compliance when any of the following occur. And that would be a change in use, expanding, enlarging, or relocating. You can't do that, or if it's been discontinued for a year, you can't do that unless you come into compliance. So if you're an existing structure, though, you're not subject to changing the height of your building and cutting off the cupola of your church or something like that, or the front 10 feet of your building that are too close to the road. You can remain lawfully non-conforming unless you completely tear it down and replace it. Parking, if you change your use or reestablish something once it had been abandoned, you do have to meet current parking requirements. This is usually one of the biggest rubs with non-conforming uses and changing uses, is the parking standards may change a lot. So if you had what was a CPA and it was in a building in a residential area, and the CPA moves out and sells it to a doctor's office who has a lot more traffic and a lot more need for parking, they would need to meet the parking standards for that doctor's office use instead of what the CPA might require. So that's what that section is saying, is that you're gonna have to, if you expand, if you change uses, you're gonna have to meet all these parking things that are in here. And I'm aware that right now you don't really have paving, striping standards and all that, so this is kind of up in the air right now. You kind of need to have some of that because of ADA requirements for handicap parking and stuff, so we're going to have to address that in some form, even limited for that. Then we have what is a minor addition. If someone just has a minor addition, which is less than 25% of the gross floor area, or adds an accessory building, the only thing they might have to bring up to standard would be parking. And then we talk about single-family uses. If you are a legally non-conforming single-family use, and that happens sometimes when you get an area that maybe is zoned industrial or commercial but has a house in it, something like that, that would be a non-conforming single-family use. They would not have to be brought into compliance with current standards when they add on their family room, for example. They're not going to have to suddenly meet commercial parking standards or something like that. Okay, then we talk about changing the structures in the floodplains. Again, just a reference to that floodplain regulation ordinance, and that is going to have to prevail. And when it comes to replacing something in the floodplain, if you do, it has to be, just like the flood ordinance says, at least 2 foot above the regulatory flood elevation. That's something, again, that's decreed by state and federal regulations. Then we get to, we talked about non-conforming uses, we talked about non-conforming structures. Now let's talk about non-conforming lots. And these are lots that might have been created that now don't meet the minimum lot size, for example, that your ordinance has. That would be a non-conforming lot. So this says basically in 403.1.1 that any lot that was legally established and recorded is a non-conforming legal lot. And that lot may be used or developed. You can build your house on it without having to go back and try to make the lot bigger to comply with current setback standards and so forth in the ordinance, but even though that lot doesn't meet current standards, you can still use that and develop it. A lawful non-conforming site, that would be something like, a site that something's developed on, I don't know, we could talk about a car lot that doesn't have a building on it, or something might be a, non-conforming site, that was there before the ordinance had standards in it for parking, like it might in the future, or something like that. That's a non-conforming site. And anytime you want to build a new building on that, or tear down something and put a new building or structure up, you would have to come into compliance with current site standards, which might include parking, which might include different setbacks for buildings, which might include driveway standards, things like that. Then we get into that same thing again, limited compliance for non-single family uses, depending on what you're doing, how much you have to meet. Same thing, exact thing that we talked about before with parking being the real big trigger there. Then we also talk about the same thing, minor additions to non-single family uses, parking again. The limited compliance for single family uses, same idea again. And then we get into signs, and signs are sometimes some of the most contentious when it comes to non-conforming standards. And particularly that happens with freestanding or pole signs a lot of times. And again, I'm aware you don't have standards in your ordinance now, so it's one of those chicken egg kind of things. We're kind of doing this one piece at a time. If we get down the road and we decide we don't want any sign standards ever, then we take this section out of the ordinance, but for now we've got it in here, just depending on what we may end up having. And so basically what we're saying is if you've got a non-conforming sign, a sign that's in place now legally, and then we adopt some new sign regulations, and that sign no longer meets what these new regulations are, that you're not going to be able to increase the height of that sign or increase the area of the sign face or something like that. We address the maintenance of the sign in here, that you can still replace the sign supports to keep it safe, but you can't add additional supports or increase the dimension. And then we talk about relocating, that you can't relocate a sign except when there is that right-of-way acquisition. Again, when county or state expands a road, sometimes they have to take additional land that might include a freestanding sign. So there are some special provisions in here about what happens in that situation. And the idea is that we want to try to keep it out of the site visibility triangle, so when somebody's pulling out or turning, it's not going to be in there. That's the basis of all that. Let's see. I'm not going to spend a whole lot of time on signs now because we don't have anything yet. It's just kind of one of those things. It's a chicken egg thing again. Same thing that we talked about with land uses. If a sign's already illegal, like if somebody's put a sign in the county right-of-way now, that's illegal. It has to be on their own property. So just because it's illegal isn't going to make it suddenly legal if we pass a new sign. So it's still going to be illegal. Compliance on signs. One of the things here that a lot of counties do is they do require signs to be removed when a business closes within so many days. And that's something that didn't used to happen, and then we had the economic downturn a few years ago, and suddenly communities had all these abandoned businesses that still had signs that said special today, and it was, confusing, and so a lot of them started requiring those signs be removed. and that is what we have for the non-conforming use section, so,
Are we authorized by statute to put a lien on our property tax for that?
are we authorized, I'm sorry, I didn't catch all
To
that.
put a lien on property tax
Oh, to do that,
for the removal?
yeah, I think communities have, I don't know if that's case
do we
law
do
or statute,
on the-
but they
I mean,
have.
I'm just thinking, if they close the business down, Travis sends them a letter that says, get 90 days
Right.
to move the sign down.
Yeah, they're not gonna pay attention.
And if he's gotta go get Amtrak, or he's gotta go get Seams with a crane or something, you know,
Yeah,
take out
it's
a
gonna
sign, that's
cost.
gonna cost some money.
Right,
And only by sticking it on the property tax, it can, I mean, that's what comes to my mind, if